we may have been closest friend. I pay tribute to his ability as a lawyer. He's a very distinguished lawyer. At the same time, above all, to his supreme integrity. So Ted, I'm sure, is with us in spirit today. I think the important thing is that he's not forgotten. So I'm happy about this donation, and he's a great guy. And one thing he's always interested in questioning me. He was always interested in me, and of course that was wonderful for me because I'm not averse to talking. And so I've been doing it for a living all my life, and it's paid off. But this man was exceptional. And he was a classmate of mine at Yale Law School, and then we went to New York together and to Nuremberg. I wanted to just brief you on one point. Mechanically, I'm going to talk on human rights in Nuremberg first, and then sovereignty. I would alert you the fact that sovereignty is a more complex subject. Talk may be a little longer. It's not as long as the one last night, but I just wanted to. I can't tackle sovereignty without doing some history, and so I'm alerting you to it. But our first subject is human rights. Now, there's no greater challenge currently confronting the international community than that of defining the scope of international human rights. At this instant, the world is engaged in a global war on terrorism, while the United States and its coalition of the willing are rebuilding the recently war-trodden countries of Iraq and Afghanistan. Consequently, the international community is compelled to face the challenges of dealing with the human rights elements of these wars, whether in the form of refugees returning to the bombarded landscape of Afghanistan, installing democratic ideals in Iraq, citizens subject to midnight raids and arrests in the streets of Pakistan, or dealing with prisoners of war who have been captured and sent to distant prisons to be later tried by military tribunals such as those being held at Guantanamo Bay. Similarly, on this very day, the world seeks to convict and punish those who have allegedly violated the rights of countless citizens, as witnessed in the trials of Slobodan Milosevic, which I witnessed on March 11th of this year in The Hague, as well as the Rwandan War Crimes Tribunal. I raise these issues not to promote or resolve the vigorous debate that such topics generate among governments, scholars, practitioners, pundits, and the media. Rather, I offer them as a symbol of where we have come during the past half-century since the Nuremberg War Crimes Trial. I ask you, why is the torture or summary execution of the Al-Qaeda and Iraq prisoners of war beyond the scope of imagination? Or why are Slobodan Milosevic and his henchmen sent to trial rather than to the roaring mobs where they would be brutally tortured and executed, as in the case of Mussolini during World War II? The answer is simply that the world refuses to accept such practices and will deem such conduct as a violation of basic human rights. As elementary as the concept is to those of us examining the issue from a 21st century perspective, let us remember that this answer was not always readily accepted. It's a legacy of justice and fairness that has led legal scholars and historians to state that Nuremberg marked the effective start of the international human rights movement. I believe that this is true. For example, under the Crimes Against Humanity count of the London Charter, certain offenses against human beings that warrant punishment are defined. In stating that these are offenses, This count, by negative implication, supports the view that human beings have the right to have protection against these crimes. The thrust of this is to recognize, again by negative implications, certain international human rights. Additionally, in the Crimes Against Humanity count as developed in the London Charter for use at Nuremberg, it is said that local law offers no out for those charged with these crimes. Put succinctly, this meant that Hitler's oral order for the final solution offered no defense for those defendants who were tried for this offense. This was the first time that it had been said that authorization by local or national authorities is not a defense in human rights cases. It meant that for the first time in history, human rights had achieved an international dimension. The Nuremberg rulings in the slave labor cases involved Albert Speer, Fritz Sauckel, and Erhard Milch confirmed that forced slavery was an international crime and should be punished as such. The rulings in the Hermann Goering and Hans Frank cases on offenses against Jews are a vital part of Nuremberg. But above all, in the subsequent Nuremberg proceedings, the findings of the courts in the Einsatzgruppe of medical experiments and justice cases reflect the conviction that human rights are not solely a matter of national jurisdiction, but that a higher law, international law, is applicable in such cases, and that human beings have status under this law. As a follow-up to Nuremberg, the UN sponsored several human rights conventions and covenants. There was, first of all, the Universal Covenant on Human Rights, followed by the Genocide Convention and the Convention Against Torture. These conventions have been ratified by many countries in the world today. They collectively constitute an international law of human rights based on conventions and customs, and also the Nuremberg Principles, which were endorsed by the UN General Assembly on December 14, 1946. The UN Security Council resolutions covering crimes in the former Yugoslavia and Rwanda incorporate the Nuremberg Principles in the protection of international human rights when they refer to, quote, crimes against humanity and genocide, end of quote. The same can be said for the Rome Statute covering the establishment of an international criminal court, which, as we will discuss in a few moments, is fully operational. Nuremberg's contribution to international human rights is found also in its endorsement of the principles of universal jurisdiction. As Jackson said in his opening statement at Nuremberg on November 21, 1946, the complaining party at your bar today is civilization. The Nuremberg court applied the concept of universal jurisdiction when it said that the nations who were plaintiffs at Nuremberg were doing collectively what each one of them could have done individually. In essence, what Jackson was saying was that some crimes that were dealt with at Nuremberg were so terrible, such as crimes against humanity, that any legitimate court could take jurisdiction of them because they were crimes against all humanity, literally and collectively. The court in the Adolf Eichmann case applied this concept in convicting Eichmann of crimes against Jews that had, at the time of their commission, no legal standing in Israel because Israel was not then a nation state. There was no Israeli law in effect when they were committed, which Eichmann could be charged with violating. But, said the court, these were crimes that were so massive that they were crimes against all humanity, and it held that Eichmann should pay with his life for their commission. The U.S. Court of Appeals in the Domaniak case endorsed this concept as included in the restatement of the Foreign Relations Law of the United States. The concept is now firmly entrenched as witnessed during its recent application during the trials of the Chilean dictator Augusto Pinochet. The inheritance of Nuremberg in Europe is reflected in the creation of the European Court of Human Rights and the convention on which it is based. Under the convention, an individual located in a member state that feels that his individual rights, as defined by the convention, are violated by his country, can bring a proceeding against his country to establish his right. If the court confirms his rights, the country must abide by the European Court's ruling or withdraw from the convention. As I have stated, Jackson's concepts on human rights are set forth explicitly in the London Charter and in his presentation of the prosecution's case. These concepts are firmly established today as we see the presumption of innocence and the right to counsel as pillars of international criminal jurisprudence. Moreover, Jackson's insistence on convicting defendants with their own documents is on stage at the Milosevic trial in The Hague, where Chief Prosecutor Carlo de la Ponte is presenting volumes of the Yugoslavian leaders' former documents in an effort to demonstrate the crime of genocide. Nuremberg added a new dimension to the rights of individuals in our world of today, an international dimension. This dimension will grow and firm up in the world of the future. We are indeed all citizens of the world, and this needs to be confirmed by a rule of law governing human rights for all of us. The history of human rights during the Cold War was particularly distressing. Indeed, critics of Nuremberg often point to great genocides and armed conflicts of the 60s, 70s, and 80s to suggest that the Nuremberg ideals have failed. It must be conceded that the legacy of the Cold War is one of sacrificing the rights of individuals for the stated goal of eradicating the world of communism. But this legacy reinforces the Nuremberg ideals. Simply, all of the treaties, conventions, and humanitarian laws enacted without effective enforcement were paper. The leaders of nation-states acted without threat of one day being brought before the bar of justice. Fortunately, since the end of the Cold War, the Yugoslavian Tribunal, the Rwandan Tribunal, the Tribunal for Addressing War Crimes in Sierra Leone, and now the ICC have all put the world on notice that the universality of basic human rights exists and will be enforced. Just and fair enforcement is the legacy of Nuremberg, and the world will achieve peace and prosperity as a result. Robert Jackson's raw courage in pressing forward at Nuremberg for the establishment of a new rule of law in the world governing human rights has vastly impacted our world of today. It means that all citizens are human beings, and that as human beings, they ultimately have certain rights that warrant recognition, just as our rights are recognized. Jackson's dream has not as yet been ultimately implemented, but I am confident that with the passage of time, we will recognize, as he did, our common humanity. Each of you must dedicate yourself to honoring his memory and his legacy through a commitment to vigilance in the face of continuing onslaughts on international human rights. Jackson led the way. Our job is to follow the blueprint that he left for us and for all humankind. The road ahead will not be easy, but it is a smooth highway when compared to the uncharted territory that Jackson faced and conquered. Truly, Robert Jackson was a giant of a man whose dignity, courage, and brilliance changed the course of history, guiding us to a new day when justice, tempered with both compassion for victims and fairness to perpetrators, will rule the world. Thank you. Well, I'll be glad. I'll be glad to answer any questions on. Yes, sir.
Would you comment on the work of Amnesty International?
Well, Amnesty International has a crack staff in London and other places. And
Use the microphone.
okay, sure. Yeah, the question is, would I comment on the work of Amnesty International? The Amnesty people are everywhere fighting for human beings. Amnesty has a very top-flight staff led by Chris Hall, who's a pal of mine, located in London, where they do a lot of the fundamental research. One thing that is needed in dealing with these issues is analytical research that can back up speakers on this issue. And on the subject of universal jurisdiction, which I mentioned, Chris Hall has written a mountain of volumes on this subject so that speakers who go out in the field and endorse international human rights have ammunition to deal with all kinds of questions. See, one of the problems is that the U.S. government, which is fighting most of this stuff, has a large staff. And we need, on the private sector, you need groups like Amnesty or the United World Federalists who have research staffs that can deal with that. So I think it's very, very important that we support Amnesty, which supports the rights of all human beings. Thank you. Any others? Yes?
For those countries that have signed on for human rights, I think it's going forward administration, what is their record?
Well, the European countries have they've signed on for human rights. They have a very good record in human rights because under the European Convention on Human Rights, if there's violation of human rights in a country, then a proceeding can be brought to challenge the action that dealt with the violation. In many other countries of the world, of course, that's not true. But in many countries such as Canada, Australia, Italy, Germany particularly, England, human rights are observed. And a growing number of countries in the Asian area are recognizing international human rights. It depends on what you mean by human rights. I think the important thing is that there's growing recognition that certain key factors identify human rights supporters. Free speech, the right that's not allowed in Myanmar, which is former Burma. At the same time, the right to vote. Slave labor is no slave labor is a human right. They're all defined in the Charter, and one of the new developments on human rights is brought out in the Yugoslav trials because they identify in Yugoslavia crimes against females, which was rape, forced prostitution. This was not fully explored at Nuremberg. So they're making new law on international human rights today at The Hague and Rwanda. So progress is being made, and there'll be a lot more when the International Criminal Court becomes a reality, because that has the most comprehensive definition of human rights that exists. So progress is being made, but it has a long way to go. Yeah.
I have a two-part question. Is the International Criminal Court, as you mentioned, an independent body or part of the United Nations, and the authority comes from a superior body like the United Nations? And my second question would be, maybe a little controversial, that perhaps do you think that it should be declared as a crime against humanity if certain countries or so on have schools that teach hatred and intolerance towards other religions or ethnic groups, like the madrasas, for instance, in the Muslim countries, that lead to crimes to humanity?
Okay, very good questions. Point one, is the International Criminal Court part of the UN? The answer is no. It's governed by an assembly of states, which are related to the UN. They're all UN members, but it's not part of the UN. The U.S. didn't adhere to that, and obviously that's a handicap for the court in being part of the UN. Your question, certain question is the teaching of hatred against people, is that a crime against humanity? The answer is that if the crime is immediately connected with murder and extermination, that it could well be a crime against humanity. But just mere expounding of hatred is not a crime against humanity. It's free speech. We had this up in the Streicher case, Julius Streicher. Streicher was the Gauleiter of Nuremberg. He was a nasty old man, the type who hangs around schoolhouses and all that. Everybody despised him, including the defendants. One of the things he did was arouse hatred, but we didn't really have any connection between Streicher and what he did with Die Stürmer in Nuremberg and the Auschwitz exterminations that I told you about last night. So the important thing here is that there was criticism of the Streicher case. The court didn't like him. He's an unsavory character. And some people said that because they didn't like him, he was hung. And he was about as nasty as you could get. But there wasn't any real direct, we didn't show definitively a direct connection between what Streicher did in Nuremberg to stir up hatred against the Jewish people and death. So that was one of the cases that some people felt was questionable. The answer is it has to be directly connected with the extermination. Certainly you could say Hitler was guilty of crimes against humanity because he gave the order for the final solution. One thing to keep in mind is that the order for the final solution, the extermination of the Jewish race, was given orally by Hitler to Himmler. There's no written order, and in a way, some people felt that Hitler was trying to keep his skirts clean, if you can picture that, by doing it orally. But there's no question that it was given from Hitler to Himmler to Heydrich and to Eichmann, who carried it out. So the important thing is that free speech is one thing, but mobilizing people to exterminate others is another. Any other questions? Maybe you've answered. Yeah, right.
There is the criminal court having specific laws to follow with specific crimes against humanity are cited and listed, or is it a matter of judgment and interpretation?
Well, on the crimes against humanity, I'll have a handout this afternoon which will show you the details of the crimes against humanity. They're very detailed. One of the reasons for that detail is that the United States, in attacking the treaty, said that, like the Ken Starr thing, it would turn a good trial might turn into a political explosion, that it would be used as a forum for attacking the United States. So when we drafted the treaty, we made it very precise as to what the crimes against humanity are, so that they couldn't generally say, well, this treaty is no good because it's subject to use by political people. We were very careful on that. We thought we identified all the objections that the U.S. had to the treaty, but that didn't prove the case. So the important thing here is that the treaty I don't think by any manner of means could be used for political objectives. There are too many sane judges. The judges on the court, 18 of them, which are headed up by Philip Kirsch, a Canadian, are either experts in criminal law or international law. They've all had experience as judges, and they're from countries such as Italy, Canada, Australia, South Africa, other places, and men and women of great repute. So this is an attempt to answer the critics. And there are about 200 cases, I understand, that are waiting to be heard. The government of Congo, I had heard, has submitted a number of cases to be heard. There are certainly cases involving Sudan, which will be heard. And the court will get underway. The swearing in is Monday, which I was invited to at The Hague, of the Argentine prosecutor. And he's a graduate of Harvard Law School and also studied at Yale, and also has tried cases in Argentina. So it's a highly creditable enterprise. It's very important that they get off to a good start, despite the U.S. attacks on the court. And there are people in the world, and I think most of everybody here, who believe in the rule of law and wish to fight for it. But there are others who don't, who believe in force and unilateralism, and who want to create a world of anarchy rather than a rule based on legal relationships. So I'm hopeful, but it's going to be the first new institution of the 21st century. There are 90 countries that have subscribed to this, and I, for one, will be watching it, and I've been asked to give my views on the role of the prosecutor. I have certain roles, which will be discussed this afternoon when I take up the International Criminal Court. Any other questions? Yes, sir. Yes, ma'am. Yeah.
What body is responsible for the enforcement of the decisions of the court?
Well, the nations who are involved in the question is, who's responsible for the decisions of the court? The nations of the who are parties to the court are responsible for the enforcement of those decisions. That I believe that they're building a prison too. I think they either have or I'm not sure whether it's in Sweden or The Hague. But the countries who subscribe to the court are responsible for the enforcement of the decisions of the court. Yes, sir.
Would you compare Nuremberg with the war crimes in Japan, the trial itself? Are they same? Rules?
Well, one of the things is I always thought Japan was sort of a sideshow. They copied what we did at Nuremberg. I prefer, one thing, I've been in 1,000 of these forums at one time or another. I've learned to stay away from questions that I don't know anything about. I felt that there is so much on Nuremberg that could occupy me for the next 3,000 years. One of the things is that I'm still growing on that, but it was a different type of setup. Didn't receive the attention that Nuremberg did. It basically used some of the Nuremberg concept, but maybe I should bone up on it, but I'll have to take a couple of days to do it, so it takes time. But your question is very appropriate. I'm not saying it's not appropriate, but Nuremberg is a symbol. One thing to keep in mind is this, that I gave a speech in the Nuremberg courtroom to the citizenry of Nuremberg, and the Lord Mayor asked me to use my influence to make certain that the situs of the International Criminal Court was Nuremberg, because he felt that the name had been blurred, and it characterized something that some Nurembergers wanted to forget. So the important thing here is that Nuremberg was the centerpiece. Basically, I don't think there were any new ideas generated on the Japanese trials. Nuremberg was created by Robert Jackson. I think it shows one thing, that individuals can change the course of human history. He was a very great man who added a dimension to human rights that never was existed before. And his monuments are everywhere. And not only at the Robert Jackson Center, but everywhere. Yeah.
Justice Jackson was the chief prosecutor for all the Allied, the 4 countries.
Yes, right.
But there was controversy originally on whether he should be the chief prosecutor or rather a justice from England should be the chief prosecutor. Am I correct?
Well, there was.
And I'd like your comment.
Okay. There's no question that Jackson was going to be the chief prosecutor. However, the real fight was between Biddle and Jackson. Truman fired Biddle as the Attorney General because he wanted his own man there. And as a consolation prize, he gave him the judgeship, the U.S. judgeship at Nuremberg. And Biddle wanted to be the chief judge, and he got into a terrible wrangle with Jackson over it, because Jackson felt it shouldn't be a totally American show. It should be a multilateral show. So Chief Justice Lawrence of Britain was nominated as Chief Justice, and Biddle was sidetracked. And then Biddle, in the cross-examination of Hermann Goering, Goering ran away with the court. He would give long answers, and they couldn't shut him up, and Jackson got mad. And there's a photograph of Biddle like this, talking to Lawrence, saying, "Let him talk." And so Biddle and Jackson crossed swords at that point. And that night, Jackson wanted to withdraw, but Biddle talked him out of it. It's a sad case, but they're both very ambitious. The one thing about Jackson is that he was the boss, and he controlled everything. So maybe that's characteristic of leadership. On the other hand, one thing to keep in mind is that if you hadn't had a strong leader, there wouldn't have been any Nuremberg. The stuff he had to deal with, his main supporter was President Truman. I mean, that's where his support came. But the American legal fraternity didn't support Nuremberg, and the American bar was weak on it. The populace was concerned with what Taft had said about ex post facto. So he had fights within the court. He's fighting with Black and Douglas at the same time. He was engaged on too many fronts, and so I think he did a remarkable job given all the difficulties. And of course, there were snide remarks from the British. But on the other hand, the Sir Hartley Shawcross, one who was there, to my knowledge, and I was there, he just came in for an opening or closing statement, didn't do anything. He wanted to claim his share of the glory of Nuremberg after it became recognized as an important trial. But you got to take the staff of 2,000, maybe 100 prosecutors in the opening and subsequent proceedings. Just getting the translation set up was tremendous. And the documents they had 475 tons of documents from the foreign ministry, which are covered in one salt mine in Bavaria. The idea of managing this whole thing was a feat in itself. And he had his troubles with reproduction of papers. Colonel Story, who was the administrative head, didn't always make sure the Germans got the documents, and Jackson was upset with that. And then he had one presumed deputy who wanted to make it a witness proceeding, just make it, while Bill Donovan wanted to make it just proceedings with witnesses. Jackson wanted documents, and so he disagreed with Jackson. Jackson sent him home. So you have to have strength in doing what he did. And it was remarkable to be associated with a man with the eloquence that he had. As I say, I worked all night on his closing statement, and I didn't get a word in because he did all his own work. Okay. Yeah.
What role did the Soviets play in the Nuremberg trial?
Well, okay, here's the point. I've got to stay by the microphone. Okay. All right, now here's the deal. They played what I call nominal role at the trial, and everybody says, well, why did you leave out the Soviets? Well, the answer was we couldn't. They won the war. And so Hitler was beaten on the Eastern Front. They beat him at Stalingrad, and they beat him in the attempt to take Moscow. So you can't ignore the victors in this thing. There would have been no Nuremberg if the Soviets hadn't defeated Hitler. So we dealt with them. I had many conversations with the Soviets, but they had the KGB over there a lot. I made dates with Soviet prosecutors to have dinner with them at the Grand Hotel, and frequently they didn't show up. And somebody said, well, he's last headed for Leipzig, which was in the Eastern Zone. So their role was nominally, they disagreed with every decision there was, but we had them there, and that was important. But we had the prisoners, that's the important thing. That's why we had the lead role. We had more prisoners because the prisoners wanted to be captured by the U.S. rather than the Soviets. Okay, yeah.
Is there an international bar association, and is there training of jurists for international law?
Well, the question was, is there an international bar association? The answer is emphatically yes. And they try to support the International Criminal Court. That's a private bar association, has very great strength in Europe, where most of the support for the International Criminal Court. And the American bar, above all, supported the International Criminal Court. Wonderful turnaround for the American bar, which was weak on Nuremberg for a long while. Well, I think, yeah.
Do you see a movement or an enterprise to establish the judiciary as the primary law-making body then under the flag of human rights?
Well, I think that human rights are so broad that it is possible that the judiciary would play a very important role, because if you get a crusader on human rights, then the judiciary might be the center. But I don't think they can do much with that statute. They can't take off because the statute's so tightly written. It's a masterpiece, I think. And you can't take jurisdiction over cases that are not within the scope of, say, crimes against humanity. That's what we tried to avoid was to have people taking off on their own on this. We wanted to build a firm foundation for the rule of law, and that's what we tried to do at Nuremberg. Yeah. I don't know. I think she supported Nuremberg. Franklin Roosevelt had not made up his mind, but I think he was headed in support of Nuremberg. I don't know.
Maybe just a little bit out of break up a little bit earlier here to get your cup of coffee, and then we can start maybe a little bit earlier also. And for those who are interested, maybe I'll actually complete this movie that you've seen pieces of,
Yeah.
so you can see Henry talk a little bit about Albert Speer, which is nowhere on your itinerary. And I was going to ask you about it, but maybe that's the best thing to do. So why don't we break now?
Yeah.
We want to come back at 10:30, which I think is 15 minutes ahead of schedule. We'll try to complete this trailer so you can see Henry talk about Albert Speer.
Oh, good, yeah. The important thing is that the two remaining sessions, the one on sovereignty is a little longer than others. The one on the criminal court is short.
Okay? Thank you.
All right.